Felix Lordship. Lordship, I am appearing on behalf of the coast. Lordship, I beg to mention item number 8 for adjournment.
Item number
8.
Your name?
Isaac Magid.
নামটো লিখি এজন কৰিছো তাৰ হলে হয় চেক কৰি দিয়কচোন
That may come up after vacation.
why do you want adjournment
Lordship, senior is having
who is your senior
the ghost.
huh
The ghost.
this matter is not of the host check up the list
Item number,
item 10 is not the host
item number 8, Lordship.
7 and 8 are technical.
but 7 she appears in 7 also
No.
let the item be called you remain I will accommodate for it
Item 1 for motion.
May I please, Lordship?
yes
Lordship, petitioner name is Jamir Hussain. The page 26, Lordship. Voter list of 1965.
who is the father of Jamir Hussain
Page 26, Lordship.
page
26.
26
Mannas, Lordship.
record I see
Mannas,
page number 26
26.
Sorry.
Mannas
Mannas, Lordship. Father is the
son of Rasul
son Ali, Lordship.
Mannas son of Rasul
Village is Shilpukhuri. Village is Shilpukhuri.
Village Silpukuri.
Lordship, correct page 36, Lordship.
Mannas is the father
Yes, Lordship.
and Jamir is the son.
Yes, Lordship.
Which document?
Page 36, Lordship. Voter list of 2005.
Two 2005.
This 770, Lordship. Jamir Hussain is a petitioner, Lordship.
Sorry. Petitioner, this one is Mannas son of Rasul
Yes,
and petitioner is Jamir
Jamir
Hussain.
Hussain, Lordship.
Jamir Hussain son of Abdul Mannan.
Mannas, Lordship.
uh,
Abdul Mannan alias Mannas.
There is no meaning alias in law. Especially in these proceedings, the word alias has no meaning of its own.
Then kindly see, page 28, Lordship. Voter list of 1975.
Page 28. Mannas Ali. Yes, Mannas it's okay. Mannas is the son of Rosan Ali. Village is Silbukhuri.
Shilpukhuri, Lordship.
That's okay, but Abdul Mannan. Abdul Mannas and Mannas Ali are two different names.
Same person.
It is your statement. How do we accept it that it is same person?
Lordship, kindly see page
See,
32.
these
32.
proceedings are of a different nature. Everything is identity. If there are two identities, we understand it is two different persons. Unless you show that it is the same person.
Page 32, Lordship. Voter list of 1989. Abdul Mannan. Village is
Yes.
Lordship. Shilpukhuri.
32.
32, Lordship.
Yes, Abdul Mannan is one person, Mannas Ali is another person. But Abdul Mannan of the page 32, he may not be a citizen because this is 1989. How will you prove it?
Page 22, Lordship.
No, you may be right, but how do we accept it without any further material?
Lordship, page 22, Lordship. Serial number 28, Lordship. Jama Bandi. Abdul Mannan.
28.
Page 22.
Abdul Mannan.
Abdul Mannan.
Abdul Mannan, we understand. Abdul Mannan, son of this Rosan, we understand. But what about Mannas Ali? Now you are trying to show that this Abdul Mannan and Manna Sali are the same person. Don't you think you need something, some more material to establish it?
Petitioner is Jamil Hussain.
We understand
Father name
petitioner
is
Jamir Hussain.
Abdul
You
Mannan.
claim him to be the son of Manna Sali.
Lordship, father name is Abdul Mannan. That is page 20.
Madam Ghosh, narration and stories cannot substitute material to substantial. You can narrate the same thing again and again. We understand if little deviation here and there, one spelling here, one letter there. But these are two totally different names. And we are not saying that they are not the same person, but you have to show that they are the same person. What onus is on you? Show it. Petitioner may produce any relevant material which may show that Mannas Ali, son of Rosan Ali, of the 1965 and 1975 voters list of village Silpukhuri in the Nagaon district, and Abdul Mannan of the voters list of 1989, whose name is also reflected in the voters list of 2005, showing him to be the father of Jamil Ali, are one and the same person. Except in the respondents in the Home Department to the Superintendent Police Borders shall also make a verification by proceeding to the house of Mannas Ali or Abdul Mannan and thereafter submit a report. Mr. Pai, it may be true also.
My lord,
And it may not be true also.
my lord, I just want to show your lordship. One thing, 79 voter list is page 30. Page 30, your lordship make full timing.
What does it provide?
The other family members are there in with Mannas in 79. But my lord, it is not a
When it
single
is
person.
Abdul Mannan, the others are
Others
also
are
not
not.
there. Oh, you do one thing. You also produce the complete voters list of 79 and of that page 30 and page 32 voters list. If Abdul Mannan is accompanied by the other family members, maybe there will be some indication. Common to somewhere over and it Manna society people.
Item 2.
After 1 week,
2 weeks, my lord.
2 weeks. Kadir,
Abdul Qadir and 5 others.
page number.
Lordship, in this case, SP Border conducted inquiry only against the petitioner number 2, that is Rahima Begum, wife of Abdul Qadir, Lordship.
So others were also included. Who is referred? Where is the reference?
Reference, Lordship, page 63, Lordship. Page 63. Page 63.
Rohima Begum.
The wife of Abdul
Yes,
Qadir.
reference to Rahima. Mr. Payne,
My lord.
come to the first sentence of the impugned judgment. Superintendent B referred this case to the then Learned Foreigners Tribunal. Allegation is that O.P. Rohima Begum, daughter of so-and-so, at the time of as it ever, along with husband Abdul Qadir, daughter so-and-so, were all resident in the Mikirweta, had illegally entered India. But the reference does not say anything like that. Why the tribunal presume that it is against many other people? The reference order we have checked up, it is only against
Rahima Begum.
Rohima Begum, not against all.
Page 63, Lord.
Report of the inquiry officer is also against Rahima Begum.
In the report, my lord, they mentioned the names of
Ah.
the family members.
Family members are there, but mind you, had it been the father, it is different.
Yes.
But this is the mother. Mother may be illegal citizen, others may not be.
My lord, my submission will be, my lord, if your lordship allows the others, my lord, your lordship may take this case only on behalf of petitioner number 2, my lord. Others may not be taken.
Others what will happen? They are also declared.
They are, in that case, my lord, their declaration may not be taken, my lord, maybe set
No,
aside.
no, but they are already declared foreigners.
That
Others.
may be set aside, my lord. And
Mm.
without going to the merit and respond, with case no petitioner number 2, your lordship may say whether it is.
Petitioner number 2, what is your submission?
Lordship, page 36, Lordship, voter list of 1965. Page 36. Abdul Hussain, Lordship, is the father of the
Abdul
petitioner-
Hussain is the
is the father of the petition number 2, that is Rahima Begum.
Rahima's father is Abdul Hussain. Which document will show Rahima is the daughter of Abdul Hussain?
Page 43, Lordship, school certificate.
43. What is 43?
School certificate. His village is same, Lordship, Amlokhi.
Madam Decca, you are here. No, this is the original school admission register. The school admission registered in original of Pati Radhika Girls High School, Botodroba, pertaining to the years 1989 to 1991, in which period possibly the petitioner Rahima Khatun was a student of that school, be produced before the court.
Lordship, copy of this.
Copy to Madam Decca.
Lordship,
List next week. Next week.
Lordship.
Item 3,
You don't have to call anybody. They'll give it to you, you give it to us. Mr. Pine, what we intend to do If the school admission register is acceptable, does not appear of any manipulation, information is correct, we can take the call here only. Why again send it back for the headmaster to be examined? What evidence the headmaster will give from the school register? We ourselves will verify it. You also verify.
Your lordship, if your lordship permits, my lord, along with the school admission register, my lord, they used to give certificate that she was a student of this school from so and so to so and so.
No, that's why admission register, when the person was admitted.
And whether he did, because I have, my lord, seen in some of the records, my lord, day before yesterday, when my lord, the SP concern was appearing, I have checked in the record, my lord.
What
Our-
more you want?
My lord, along with the class registers. of
Along with the class register.
Attendance
Class,
register of each
along with the attendance, students attendance register.
class- of each class, because he will have to pass, they are giving that certificate that he have passed on so and so.
But
That record is nowhere, my lord.
fine. Very good. No, what we, instead of again remanding every matter, they'll do the same thing, again come, again one more repetition.
Yes, ma'am.
Why don't you take a final call? You also be satisfied. If it is yes, allow them. If it is no, we'll see what is to be done.
Always.
Continue on the false evidence, or you can draw up some proceeding. And if there is manipulation, false evidence, we can draw proceeding against those people who are giving these certificates and all. Yes,
May I please, your lordship? Page 36, your lordship.
36.
Petitioner's name appeared in the
In
final-
fact, Mr. Payeng, this work should have been done by the tribunal long time back.
Yes. Procedure, my lord.
Instead of going to all directions, tribunal could have easily done that. They have the power to call for these records. CPC is applicable, they have the power.
My lord, the understanding was that so long. My lord, it is the duty of the petitioners to prove. If they do not bring this, my lord, the tribunal used to reject.
No, this is where they went wrong.
Uh,
They don't
Yes,
have to
because-
give 100% complete material. Even if it's a partial material, but that indicates the burden is discharged unless that is rebutted. There is no law that it has to be 100% complete.
That is true.
If 25% material also indicates, just because 100% is not produced, you cannot reject that 25%. What you'll have to do is to rebut that. To rebut that, best course is come to a final conclusion. Check it up yourself whether it is a yes or no.
Now I have directed everyone to remember that they only as
I
it
think
is.
everybody's work will be lessened if
Yes.
a little bit of more effort is given.
That's
And most importantly, the decision will be correct. There will be very few cases which would require any interference by the higher court also. Yes, which page you are referring?
Lordship, page 36, your lordship.
36.
Petitioner's name appeared, your lordship. This is a final Khatiyan of 6152, your lordship.
It's a Khatiyan.
Final Khatiyan of 61. At the time, he was minor, your lordship.
Khatiyan of which year?
This 1962, your lordship.
Where is the date?
Page 38, your lordship.
38 is the date.
Record of
Hmm. So where do you find the date of the Khatiyan?
lordship. Original may be page, your lordship.
Is it below?
Lordship below.
That's 712 something.
Lordship. Left side of certified to be true copy, your lordship. Dated.
Okay, fine.
six-
So now what information this one contains?
Petitioner's name is appeared, your lordship, page 37.
Page 37. Where do you find the name? Petition is
Below lordship, your
Motiur Rahman.
Motiur Rahman.
Motiur
He
Rahman.
was minor at that time, your lordship.
Maybe that is maybe. There. And Rezak. What is Rezak? Rezak.
Razzaq Ali, his brother,
Rezak Ali. Who is Rezak Ali?
his brother, your lordship.
Acha, both are sons of Abdul Rahman,
Abul Kalam Azad, your lordship.
Abdul Kalam Azad.
Late Abul Kalam Azad.
This is Khatian of which village?
Dubasuri part 1.
Sorry.
Dubasuri Patam Kondo, your lordship.
Gaon Dubosuri part 1.
Petitioner father,
What's the age of the petitioner?
at present, your lordship, petitioner is about 71.
61. Yes, Mr. Pine.
If he's 71, there must be some other documents also of 1971 voter list also in there, my lord. If it is the same.
71 voter list, it will not come because he is a 71-year-old man. He must have been born sometime in early 1950s.
Yes, my lord.
Yes, he-
In
So it is
51
it's
NRC
not
that
71, at least some
At least 71.
75 or so, his name will be there.
voter list is not there, your lordship, but the,
This man is not interested in voting.
I don't know, lordship, there is no,
Mhm.
draft sita is there, your lordship.
Sorry,
Draft sita is there, lordship. Page 52.
no, this man never voted.
Voted in the 1997 voter list.
Where is it? Page number
Page 42, your lordship.
42.
Lordship. Serial number 653, Mathiaram. The voter list belongs to Dubasuri part 1, your lordship.
How to go in a voter list? The voter list to come in a voter list of number. So his name was entered in the voters list for the first time when he was 40-year-old.
Lordship.
58 years.
But your lordship, register sale date also there, 1982. Page 47.
Where is the name of Razak Ali in the voters list?
Razak Ali is not there. Razak
So
Ali-
one
Razak Ali-
brother desired his name will be entered when he is 40-year-old. Other brother never entered his name in the voters list.
Lordship, my instruction is that in 1982, the land sold by both the brother and one Razak Ali has shifted to other place. Your lordship.
It cannot be one Razak Ali. It has to be the brother Razak Ali.
Brother, Razak.
Confusing.
There is no other family members, in only two. only.
The
Yes,
superintendent of police border of which district?
Bongaigaon.
Of Bongaigaon district to make a verification as to whether the petitioner proceedee Motiar Rahmans, to whom the notice was issued,
Mathiaram.
son of, where is the notice?
Notice not annex, your lordship. Son of Abul Kalam Azad, late Abul Kalam Azad.
Not now, you are claiming notice maybe to somebody else also. Motiar Rahman of FT case number
Page 30, your lordship.
of case number
DN.
BNGN bracket 2 stroke APR stroke FT hyphen 115 stroke 2019. And Motiar Rahman, son of Abdul Kalam, whose name appears in the final Khatian, dated 7/12/1961, in respect of a plot of land at village Dubasuri, first part, are one and the same person. Make a verification. If
Yes. Interim may be there. Interim.
it's coming for the first time.
Lordship.
Full interim to nalage. Till the next step, no coercive action be taken. Further interim orders shall be considered on the receipt of the report of the
Lordship,
notice. to nalage.
One humble submission, madam. There are some typical mistake in
Correct.
both.
Correction you do it.
Before the registry, in the record also, in the website also, it will be corrected.
Stated that some inadvertent mistakes are there in the repetition and
Mufti
the
Rahman.
council intends to make a correction.
And-
Correction may be allowed by the registry.
Hello.
Item 4,
Yes,
The record was called for LRC.
School
in connection with
admission
Annex
register of
14 is 50.
got the register. Yes, Mr. Payeng, examine the register first. See how you see it. Put on
No, your lordship may fix the method on Monday, my lord, I'll go.
The record, the school admission register in origin of 377 Gaspara LP School has been produced before the court. Mr. J. Payeng, the Home Department seeks my adjournment to examine the same, list on so and so.
If your lordship, my lord, gives another date, my lord, your lordship may call for the admission, class attendance register from class. Because. as
The
per-
class admission register of for the period so and so be also produced.
Up to class 3, because 1, 2, 3. Then your lordship may fix after 1 week. my lord.
Where will you retain all these records?
It's in the government. office.
Government.
Government.
In education.
You have the storage place to retain it safely. Okay,
Under the education department, not with us, my lord.
sorry.
Not with us, my lord. It's not with us, my lord. It is under the education department.
If you have, you please maintain.
Yes. I'll-
Produce the next day along with that one.
Yes.
And if the information is correct, we'll finish
Yes,
the
yes,
matter here
Yes,
only.
yes.
We don't intend to again send it back.
There is no manipulation, my lord.
Ah.
Your lordship may be-
And if it is not, see what is to be done.
Yes. Only I will go through, my lord.
Because we have to reduce these pendencies, no?
Yes,
Just
definitely.
shutting between the High Court and the tribunal again and again, it's of no one's benefit. Take a call. If the tribunals are not taking, we'll take the call.
item 5,
Obliged, Lordship.
It will be about finally. Yes.
My lord,
It's all
lordship
of the
may kindly
clear.
have a look at page 42, voter list of 1970.
Who is J.A. Sikdar?
Father's name Lalmia,
Mr. Who is J.A. Sikdar?
my lord.
Who is J.A. Sikdar? I'm asking him. Who is J.A. Sikdar?
A.R. Sikdar, my lord.
J.A.
Oh, J. Sikdar, he is my lord.
Your son?
No, my lord.
Somebody else.
Somebody else, my lord.
Okay.
His father is known to me for a long period, army personnel.
Tamsir Ali, who is the father?
Father, my lord,
Lalmia Sheikh. Where is this?
Lalmia Sheikh, lordship will find at page 42, 43, my lord, 11 person, Lalmia, son of Dhoni Mullah.
43, Lalmia, son of Dhoni Mullah. Tekona.
My lord, village Tekona,
And which document will show that Tamsir is his son?
my lord, at page 106, my lord. Jamamandi, village Tekona. The first Patadar was Lalmia. Then my lord, Tomser is at serial number 43. with along with other brother and sisters. Barnakular also.
Notice injury?
Notice, Lordship.
Mr. Sigari. In the writ proceeding, the petitioner relies on the voters list of 1970 of village Tekona, which contains the name of Lal Mia, son of Dhoni Mullah at serial 56. As well as the Jamabandi in respect of a plot of land at village Tekona, which contains the information that in place of Lal Mia, son of Dhoni Mullah, the land had also been mutated in favor of Tomser Ali, son of Lal Mia. It is claimed that Tomser Ali of the Jamabandi is the petitioner himself.
Item 6.
Six, yes.
My lord, here, my lord, the petitioner's father's name,
Ajuba Khatun,
my lord, Wahab Ali,
page number.
page 27. Total list of 1966, 70 also. Father's name,
Page
mother's name,
27.
27. Wahab Ali's father, Hansan Bibi's mother,
Wahab Ali, son of Allah Box.
Well-
Wahab Ali is the father.
my lord.
And which document will show?
My lord, only my lord, Panchayat secretary certificate.
You know the law.
My lord.
Then
My lord, brother was examined and Panchayat secretary was also examined, my lord.
how do you know he is the brother? How do you know that he is the brother?
My lord,
Where is the name of the brother and Wahab Ali together?
my lord. At page 44, my lord.
Page 44,
34, my lord.
34.
34. My parents are there, both mother and father. Abdul Manabi's brother,
Abdul Manaf is son of Abdul Wahab.
Abdul Wahab,
He is not Wahab Ali.
my lord.
And moreover, Abdul Wahab is the son of Jinnat Munshi and not Allah Box.
My lord, in
This page 34,
yes, my lord.
even if you say Wahab Ali and Abdullah Wahab are same, but the fathers are different. Abdul
Villages
Wahab is
also
Jinnat
different.
Munshi and
Jinnat
Wahab Ali is Allah Box.
Villages
My
also.
lord, they may
Village is also different.
Yes, Lord.
One adjournment.
my lord.
Adjourn on the prayer of Mr. A. Singhal to examine as to who is the father of the petitioner. A claim is made that Wahab Ali, son of Allah Box of the 1966 voters list of village Chor number 6 is the father. To establish that Wahab Ali of the 96 voter is the father, reliance is placed on the evidence of Abdul Manaf. Abdul Manaf, son of Abdul Wahab of the 1985 voters list of village
Futuripara.
Futuripara. But it is noticed that 66 is list is of village Chor number 6, whereas 85 list is of village Futuripara. And secondly, Abdul Manaf is the son of Abdul Wahab, where Abdul Wahab is the son of Jinnat Munshi, whereas of the 1966 voters list, Abdul Wahab is son of Allah Box. Mr. Sigdar prays for an adjournment to examine the aforesaid inconsistency.
Item 7 and 8 for admission.
Yes, 7 and 8. 7 and 8, somebody wanted adjournment,
Yes,
but Madam Ghosh is only for 8.
Yes, sir.
Who appears for 7?
I know there was a different council.
You appear for item 7.
Lordship, my senior counsel is out of station.
So you also want adjournment.
Yeah, yes, Your Lordship.
Both of you want, it's okay, but we did not want to adjourn one matter. Both your names.
Yes,
MD A. Rahman.
Lordship, 7 is tagged with 8.
That's why
Something.
something must be. Both Mr.
MD A Rahman.
M.
Rahman.
M. A. Rahman.
A Rahman, Your Lordship. Aminur Rahman.
A Rahman.
Both Mr. A. Rahman for the writ petitioner in WBC 3576/2017 and Mr. S. D. for the appellant in WA 173/2022 seeks for an adjournment. Adjourned list.
Item 9.
May please, Your Lordship.
Item 9.
My lord, here, my lord, father's name lordship will
Rahimuddin.
find at page 24.
Page 24.
24, my lord, Karim Sheikh. Karim Sheikh and Saji Bibi are parents. In
Karim
village
Sheikh is the father.
Father,
Karim Sheikh father. But and Saji Bibi mother.
Yes, my lord, Saji Bibi is mother.
Village
is
is
also village-
Kandulia. Which
Kandulia.
document will show
My lord, village,
Rahimuddin is the son of
total list
Karim
of 1985.
Page number
Page lordship will find at 28.
28.
My lord, we have also given a vernacular copy, page 29. In translation, there is some wrong entry of the serial number,
Vernacular is very difficult to read.
my lord. Qasim Sheikh, Shokina,
Serial number
my lord, serial number 229.
2
229,
229 is on the left hand side.
my lord.
226 to the
In the first
229.
column, my lord,
229 Karim Sheikh.
Karim Sheikh. Then, my lord, 2,
A son of
3,
Mur Akan, some Akan, Mur Akan or something.
my lord.
Mabu Akan, maybe Mabu Akan also.
Mabu Akhan, my lord.
Well, so now
My lord, Abdul Rahim is at serial number 233. Son of Qasim.
233
233
Abdul Rahim. He is the petitioner,
is the petitioner, my lord.
son of
Qasim.
Qasim. And this is voters list of Gaon,
Of
Kanduri.
same Kandulia.
Kandulia. Let it go back.
Yes,
You produce all the in between voters list.
My lord, will produce, my lord.
Third, Mr. Yes, Igdal, council for the. No?
Careful, काम करा किसी को, पहले से एक तस्दीक careful हो.
Heard Mr. Yes, Igdal and counsel for the petitioner also. I think. The petitioner Rahimuddin had been referred to the foreigners tribunal number
Infun order.
foreigners tribunal number
Foreigners tribunal
number
number 10
10.
opposite.
Borpeta for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 102/2016. The tribunal rendered an opinion dated 1/9/2017 declaring the petitioner to be a foreigner. Being aggrieved, the said petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Kandulia, police station Bagbor, in the present Borpeta district, which contains the name of Karim Sheikh, son of Mabu Sheikh at serial 89, and that of Saji Bibi, wife of Qasim at serial 91, where both are residing in the same house number 30. And it is claimed that Karim Sheikh is the father and Saji Bibi is the mother of the petitioner. Further reference is made to the voters list of 1985, also of village Kandulia, which contains the name of Qasim Sheikh, son of Mabu Akand, at serial 229, and that of Abdul A. Rahim, son of Qasim, at serial 233. It is claimed that A. Rahim of the 1985 voters list of village Kandulia is the petitioner himself. But it is noticed that in the voters list of 1985, the name of A. Rahim, son of Qasim, appears, whereas the present petitioner is Rahimuddin. So a question would remain as to whether Rahim and Rahimuddin are one and the same person. But however, as a claim is made, we remand the matter back to the tribunal to examine the aforesaid aspect. Firstly, the petitioner will have to prove through any other reliable material that A. Rahim of the 1985 voters list and Rahimuddin, the writ petitioner proceedee, are one and the same person. The petitioner to also produce the complete voters list of village Kandulia from the year 1966 to 1985 for examination of the tribunal. The respondents in the Home Department may also make their own verification on the aforesaid aspects as well as on the authenticity of the voters list and submit a report before the tribunal. Upon doing the needful, a reasoned order be passed.
Item 10.
Lordship, this item, my friend may serve me a copy, Lordship, all the pages are upside down and pagination is all mixed up. Very difficult.
one?
Your next item.
Thanks. Yes, my lord, yes, madam.
Copy this in.
Yes.
On the request of MSC Verma and Council for the Home Department, the petitioner may serve a better copy. of the
We'll
report.
give a proper.
This next week.
Item 11.
Yeah, it will. Okay.
My pleasure, Lordship. Lordship, earlier occasion directed us to produce the complete total list of year 1966, 70 and 79 of village due to you. As regards the petitioner's mother, I am on a Khatun, your Lordship. As your brother, she is the same person. So from the voter list, your Lordship, and the family, yeah, all along the same petitioner's names are appearing. So petitioner and the other family members are appearing together, your Lordship. So she's the same person, although in the 1979 voter list, the name of her.
Why, let us read in the meantime. But it's an already interim order is passed. May clear petition or leave. If further voters list produced before the court is kept, how will we tell you? No, today why has it come? Records are already available.
Lordship.
So only one line is a voters list produced before the court by the election commission is kept on record. Can you hear the matter today or what? Hmm? Can you hear this matter? But it's a matter hardly 1 month old.
Yes, Lordship can fix it up for another day.
Why?
I have not gone through it. What was the last order? No? Or Lordship can send it back.
Send it back.
Yes, Lordship.
Why? I'm yet to hear.
Can you give it to me?
Also in 1979 voter list, your Lordship, the mother's name of the petitioner, Aimona Khatun Bewa, this Ahmad Ali it's came, your Lordship. Whereas in other voter list, the name of the petitioner, Aimona Khatun, was Muhammad Ali. So your Lordship is directed us to make whether Aimona Khatun, so wife of Ahmad Ali, and Aimona Khatun, wife of Muhammad Ali, are the
Ahmad
same.
Ali and Muhammad Ali were the same person.
We have verified the complete voter list. All the petition family members are same, your Lordship.
Other family members
Other
are
members are
same.
same. They are all along in the same house. They are appearing. And in the 1979 voter list, along with Aimona Khatun Bewa, the name of Ali Akbar, the petitioner name. appears.
Ali Akbar, okay. Heard Mr. Am I Hussain and what is it? Am I Hussain and counsel for the petitioner also heard. The petitioner Ali Akbar.
Yes, Lord.
We don't want all these aliases. It's very confusing. Who is the petitioner?
Ali Akbar, Lordship.
Ali Akbar, son of
Son of
Son of whom was it then? Ali Akbar?
Ahmad Ali. Ahmad
Son-
Ali, Muhammad Ali.
what is the actual name? Ahmad Ali.
Yes, Lord.
Ali Akbar, son of Ahmad Ali of which village?
Of village Dev Dhuturi.
Of village?
Dev Dhuturi.
Dev
Dev Dhuturi.
Thuturi.
Yes.
Of village Dev Thuturi had been referred to the Foreigners Tribunal number.
ताते ही इधर दिया लाइन में।
Which page is the order? Tribunal order
Order at page 61. Lordship.
61.
Sorry, look here. 62, Lord.
62.
Yes.
Had been referred to the Foreigners Tribunal number 1 Bongaigaon for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number page 62. Number report, all seals are there. I don't know how to read it. What is the case number?
Case number 62 in
Hmm.
order.
No, all these round seals are there on top of the number.
Yes,
It's
Lord.
not very readable. Do you have the number anywhere else? Relative registration, case number so and so. An opinion dated 21/12/2022 had been rendered declaring the petitioner to be a foreigner, being a district petition is instituted. The petitioner claims that he is the son of Ahmad Ali.
Muhammad Ali. Muhammad.
First you said Ahmed Ali, now
Yes,
you're saying
that-
Muhammad Ali.
That is 79 voter list appears. And 66 and all other.
Adjourned to be listed again. The petitioner may first take a clear call as to who is the father of the petitioner. We can't go on oscillating with your varied statements all the time.
Sorry.
Next item. First you decide who is the father of the petitioner. Once you're saying Ahmed Ali, again you are saying Muhammad Ali. Who is the correct name? Tell us that. Then we'll examine.
Obliged.
Item 12.
Ahmed Ali will be Rasule. Ahmed Ali, পিছত আকৌ কৈ দিয়ে Muhammad Ali. So first you have to make sure who is your father. Then you can arrive at conclusion. The Muhammad Ali to Mr. M.I. Hussain, first you have to take a call who actually is the father. Only then we can decide. Just because one document is Muhammad Ali, one document is Ahmed Ali, in our judgment, we can't go on oscillating between Ahmed and Muhammad to describe the father. First, you take a call who actually is the father, then we'll examine the documents, whether it is acceptable or not. Because our judgment started with the word son of Ahmed Ali.
Yes.
Now in between you are saying son of Muhammad Ali. What will you write now in our order? We can't decide you are the son of Ahmed Ali and Muhammad Ali both.
Yes.
It has to be one. If a document is wrongly showing Ahmed Ali is Muhammad Ali, that is another factor. We'll take a call on that. But one document saying Muhammad Ali doesn't mean the petitioner becomes the son of Muhammad Ali. Okay. Yes, Mr. Bhagawati.
Regarding the requirement of sanctions, that day we have already concluded. Lordship has already.
Anything more? Cost?
Lordship, for that.
How much?
If possible, if it is waived for the first time. being it is for the first time.
Don't say make it a cost negative that the court will have to give you money now. Don't say that a cost will be in a negative terms. So now the court will have to give you money.
So Lordship, that I
No.
will, that I will not.
You don't want. Then how much?
The Lordship will decide. Lordship will decide accordingly.
Cost we deleted, rest of the order we retain. On your plea of that party also we reject it. We put it in our order that this way issue was raised, we are rejecting for the reasons we have already given. And regarding the other one that L Subramania or something, no? That
Narayan,
Narayan Swamy, sorry. There the
That's
Supreme
clear
Court is very clear.
Clear.
Even the learned single judge in the other matter had clearly understood and recorded it.
But
And in para 19, I think.
Para 12, he has rightly elaborated.
But in the next
In
paragraph,
paragraph 13,
takes the other
Another
view.
another view.
So if you want, you file appeal against that man. If the state is advised, if the state is not advised, don't file, let him take the benefit of the wrong judgment. But here we have to take the call the other one.
that noise since.
And after deciding the reference, what do you do? Send it back to the learned single judge or we decide it ourselves?
Lordship,
I think we decide it ourselves only again.
That can be decided because reference has been sent for.
No,
So.
we take a final call also. Again, why keep a formality of again sending it back to the learned single judge?
He may not be required.
Ultimately, the whole thing is decided. That L Narayana says it is
Correct.
this one. And if it is that one, that's the law and
Lordship, when the present petitioner has filed the petition.
do you have any other ground? Now tell us.
Yes, I have seen the petition, their petition. Some
Other
other,
than this paragraph 12 of Narayana, do you have any other ground? Because this is only a reference.
this is only referring.
And we are answering the reference in a particular
Only
manner. But that doesn't mean you cannot raise any further submission. Do you have any further submission? Or that was the only submission?
Some other, please.
Your argument is based on the judgment of the learned single judge in the other revision.
That is.
I also want a similar order. Or you have some further submissions to be made against the impugned order.
Some other points are there in the petition.
Please argue.
So these points were that.
Maybe he has a different legal issue to be raised other than Narayana.
And if he has it, other than that, because sanction was the main issue here. The other issues were there.
No, no, on the sanction, maybe he has another
that-
legal
that
issue.
he-
Possibly, he may have. Do you have?
Regarding sanction, I have no other argument. But in the original petition, which is lying before the honorable single bench for the present petitioner, some point was taken.
No, this petition is already before us. It's not lying anywhere.
But when referred, only two issues they have referred. For that reason, I am submitting.
Mr.
But-
Bhagavati, have you understood what we are
I
asking
have understood.
you?
I have understood that this.
We will answer the reference question that is referred to us.
Lordship.
Now we are asking you, should we decide the original petition ourselves or having answering the reference, we again send it back to the single judge?
It can be sent back, Lordship. It
Why?
can- Oh,
Why?
or otherwise, otherwise,
That's why I'm asking. If it's a futile exercise, everything is done here only. Let's bring a finality to it. So we are asking you, other than the legal issue on which the reference is made, which will be answered in a particular manner. In the original petition, do you have any other legal issue to argue?
one issue I can raise.
Please
that-
argue.
That issue was that when final report was submitted in before the special judge, now to that final report, the learned special judge disagreed. And what learned special judge did, he issued the notice to those complainants who are the two presidents and secretaries of one NGO. They have originally complained that some misappropriation has been caused in respect of landsliding.
So what is wrong if the special judge
Ah,
gives notice
Lordship,
to somebody else?
Lordship, then after calling them, they were examined. But from the special court's impugned order, special court's order, it is not appearing that whether they have submitted any written statement before the learned special judge, or whether they
No,
have
but
got
that,
some more
understand, that will be an issue of in the trial.
issue of trial.
Ah,
But since
The
but-
issue, the question you are raising,
Lordship,
that can be taken up in the trial.
but whether
If
that-
those, now what will happen? The two persons who were noticed are likely to be witnesses in this case in the trial. I think
In the
they'll be
trial.
witnesses.
in the trial,
Once they are witnesses, you can always cross-examine them, whether if a given document or not given document. Implication of not given document will be a question in that trial.
but regarding the current.
But how, but at this stage, why should he preempt everything?
Because if cognizance, we are challenging the cognizance as a whole. If cognizance
And what
goes,
is cognizance?
Lordship,
What is cognizance? When cognizance is taken, when cognizance is not taken? Please submit on
there
that.
should be some prima facie case should be there,
Prima facie
Prima
case,
facie.
not conclusive case.
not conclusive.
So prima facie case, they have enough material. Only thing, what the special judge had done, special judge issued notice to two persons. Possibly they were the complainants or somebody
They were
of the
complainants, one came-
organization where
One came, one
this
didn't.
defalcation of money had taken place.
Lordship,
They came before the tribunal. They deposed before this special judge. That deposition was also taken note of while taking cognizance. Now you are submitting that those witnesses did not support their evidence with any documentary evidence. So evidentiary value may be little less, evidentiary value may be little more, or evidentiary value may be absolutely no value at all. Either of the three is possible. This is an issue to be taken up during the trial. Because those witnesses will again be examined. Or you can always call them to be cross-examined if they are not again examined. Then you test the veracity of their evidence at that stage. So when there is a possibility of this evidentiary value being less, how can we at this stage of taking cognizance declare that that evidence has no value? Don't take note of that evidence. As the order taking cognizance also takes note of that evidence, the cognizance itself is bad in law, interfere. This is little preposterous.
may I submit one point?
Submit more points, doesn't matter,
But
provided it is something relevant to the context.
Lordship, learned special judge, if after recording the evidence, but from the special judge order, it is not appearing that whether it was recorded or not. Just simply it was found that they were called. Now, whether statement was recorded,
How does it matter to you?
and one more thing, that could be done, that some further investigation, if directed, after that IO has done some further more investigation and could have brought some more material to take cognizance. Otherwise, the final report, IO has furnished his opinion that is a not
See,
case is made out.
If the final report of the investigation, along with the materials produced before it, is good enough to take cognizance, for the special judge, that is enough. What more materials are coming, what more investigation is required, what one witness will say, what scope you have to demolish that evidence of that witness in a trial. These are not issues
Yes.
to be gone into by the court at the stage of taking cognizance.
Because that will be a matter of trial later on.
Trial, you are free to do anything. But at the stage of taking cognizance, you cannot preempt by saying that in the trial, I have a very, very strong case in this manner, because I can demolish the evidence of that witness. So therefore, don't take cognizance. This is, I think this is against the criminal law jurisprudence. See, whenever we are exercising jurisdiction, either for quashing of FIR, quashing of charge sheet, taking cognizance, the test is different. When you are deciding something in appeal of a concluded trial, the test is again different. You cannot borrow the test of a appeal to the principles of an appeal and test the cognizance or FIR or charge sheet at the quashing stage. Because application of both the stages are different. Here, only the minimum of material is there or not to arrive at that satisfaction. It's not a conclusion. Other one is a conclusion. There you'll have to give strict interpretations to all kind of issues you are raising. That this evidence could not have been taken into account, this evidence is not reliable, this evidence is being rebutted in an appropriate manner. These are available in the final stage.
But usually when final report is accepted by the trial courts, then a complainant is called and
The trial court has every right and responsibility within itself not to accept a final report as given by the investigation, because this is a check and balance that the system has put into place.
Then
because sometimes the investigation may be motivated.
motivated.
So therefore, law does not leave everything to the investigation. Law requires a judicial scrutiny to be made on that final report. Otherwise, if the judicial scrutiny is taken away, you just go and influence some investigator here and there. One investigator is little unscrupulous. That's the end of your investigation against you. You managed everything. So this is a check and balance put in that even if there is a final report, it should be subjected to a judicial scrutiny. And in judicial scrutiny, the judicial authority may take either accept it or not accept it also. And if the judicial authority is of the view that there is good enough a material for trial, it's a good enough a material. Please the impugn order. Which portion of the impugn order is incorrect, requiring deference? So now tell us why this order requires interference in revision.
Lordship, this order has been, a read petition criminal number 2 of 19 is still kept pending. Not disclosed.
No. Nothing is kept pending. Writ petition 2 of 19 had been renumbered as WP criminal 22/2021. It is the same petition. This is the record. It's not pending anywhere.
There are 22 of that single judge order reflect. This bench is not disposing the present petition as the referred two issues would have. to be
Understand. Now the whole thing is before the referred bench. It's not pending anywhere. What is reference? Reference, everything is sent to the referred court. Reference is not that I am keeping the file here and only sending the order to the referred court, answer this and send it back to me. That is not reference. So if you want to argue on this, argue today or next day. Up to you.
I would like to take
See-
one adjournment.
See what further ground you have.
Lordship.
Why should
that
I
can-
send it back again?
Yes, it can be decided. Here, the whole thing has been referred ultimately. And only ground is the cognizance issue. And the notice, which was the, which he was probably saying, 173 notice.
If you say that special judge had deviated from the established requirement of law in any manner, point it out.
Lordship, for that, for deciding this, may LCR be called for? Because
What will be called for?
LCR of the original pen which was pending, because some fact has to be looked into.
What
Also,
facts has to be
that
looked into?
cognizance has been taken.
No,
Record
Lordship,
probably will be required.
Lordship,
That-
only two, Lordship may kindly peruse their petition. Only two grounds they have taken. One is that is for cognizance that, the sanction is required or not. That is one issue. And secondly, one other issue was that whether notice to be given to the complainant or not while taking the cognizance under 173 of the CRPC. That was the two issues, two grounds they have taken. No other grounds have been taken. Because page 4 of that petition, Lordship peruses, these are the grounds. Only two grounds I can make out. Lordship.
You argue on the two grounds. We'll hear it.
Lordship, to find a prima facie case, the materials dealt has to be.
You must be having everything with you. Which line requires any further material? Tell us from which paragraph, which line of the order requires more material.
Like,
That is
If
not
we- if we-
completed.
if we-
See,
case.
we'll not allow you to just go on arguing in a vacuum.
Those are not grounds, Lordship.
Now, suppose we allow him to take additional ground also. Read it, tell us.
Lordship,
How
one,
can you prepare a ground by requiring the court to first call for the record? You call for the record first, I'll go through it and then create my ground. Where is that procedure available? First, you create your ground. Do you expect that before filing a revision, you'll be allowed to have custody of the records first? Then I'll prepare my case and file a revision? Never. So you prepare your thing, and if the court feels there's the requirement of any record, the court will call for it. First, you have to formulate your grounds.
My ground is that to find some to arrive at a conclusion.
Mr.
that-
Bhagavati, we are getting a little impatient with this litigant before this court. He is more interested to just delay and defer and do all kind of things rather than facing the court in its proper perspective. Slowly, we are getting that impression. We have given you an additional opportunity that beyond the grounds you have taken, do you have any ground? First, you urge upon your ground. We cannot allow you to say all kind of things that for creating my ground, I need all these materials. What is that procedure under the CRPC? And who stops you from inspecting the records wherever it is? Inspect it. You are venturing into a luxury. That first give me the record, then I'll create my ground. And have you gone through this order till now? Have you gone through the impugned order? Have you read the impugned order? You have read it.
I have read it.
Which line, which paragraph is offending?
3-5 special judge order, Lordship.
First, you have to show us what you have to decide. And then only the next step will come.
Page number 4 of the impugned order.
Yes, page 4, what is wrong?
Lordship, 1, 2, 3, 4th paragraph of page 4 of the impugned order. One paragraph I am reading. It is submitted at the bar that PU H so and so is presently posted as secretary to the government of Mizoram Health and so and so.
This is the issue we have already decided.
Uh,
What will be the effect of requiring or non-requiring sanction when the man is posted somewhere else?
I am just pointing out another thing. So here, the learned trial magistrate has concluded that the two persons were holding some different posts at the time of commission and during the taking of cognizance. Now, for instance, that from which document he has arrived. That issue has also to be decided, that whether at the time of commission of the offense, that particular person was holding some different post. That is also a question of fact. After
Understand, you answer the fact. You know the date of commission of your offense. You know the date of taking cognizance. You tell us on which date, what post you are holding.
some materials.
See,
But here,
see, Mr. Bhagavati, read the Evidence Act. The facts which are within the knowledge of the person alleging, it is for that person to disclose before the court. Read the section.
But during cognizance, I didn't get the
Mr.
opportunity.
Council 106, read it. It is well within the knowledge of this petitioner. He knows the date when the alleged offense had taken place. He knows what post he was holding on that day. He knows the date when cognizance was taken. He knows what post he was holding on that day. So now, who is to prove this fact? If you go by section 106, it is you who have to prove this fact.
Had it been in trial, I could have
Mr.
get
Again, you are going under theory of doubts and doubts. Theory of doubt has no place in criminal jurisprudence. Theory of doubt is only the final stage of a concluded trial that prove beyond reasonable doubt. Every stage, every line, doubt is not
So
applicable.
these are the things to
You
be
know.
argued after the trial is over.
Huh.
Now trial hasn't started as yet, and evidences hasn't come as yet, documents hasn't
You are
been
arguing
raised.
more in the line of an appeal rather than.
It's, yes, Lordship, this is like, it's in a very preliminary stage, cognizant
So
stage.
if these kind
Only
of arguments
qualification
are
statement.
entertained, every stage you create an obstacle, there will never be any criminal proceeding against anybody. Although that's an effort of a good lawyering of some people, but that cannot be accepted. Yes, every step I'm going to create an obstacle. And Supreme Court has deprecated it, that revision, repeated petitions before the higher court at every stage is to be deprecated. At one point of time, it was a concept of lawyering, but that has gone now. It's no longer available. See all the Supreme Court judgments of the last 15 years. You'll find this concept in many number of judgments. At one point of time, about 20-25 years back, it was a very novel concept of of lawyering. Every step you raise a question, go to the higher court, get it answered. So ultimately, the prosecution gets fed up. Let us close this matter. So please be more true to the system, argue if you have anything.
So that was, Lordship. So then
And
that's
this
the-
paragraph, our answer is simple, we'll answer it. This is a fact within the knowledge of the petitioner, which cannot be questioned in the revision to be proved by the 106 of the Evidence Act. See, in the breakfast, what I had this morning, if I ask Mr. Kolita to prove it or ask Mr. Bhagavati to prove it, can you prove it? No. Why? Because it's a fact within my own knowledge, what I had in the morning. So now if that is an issue, what breakfast today I had in any proceeding, can I throw it to somebody else that you prove it first with what breakfast I had today, then we'll proceed further. Even if I raise that issue, it's for me to answer, not for you to answer. So what post this man was holding, it's within his knowledge on the two respective dates. Anything more?
No more.
Yeah, my heavy babies. You read well and come back, there are good grounds for you.
Okay.
Don't go into these petty issues. Read the order properly. There appears to be some grounds for you. Argue on a good concrete ground, which is likely to lead to some favorable order in your favor. And not all these petty things here and there.
I'll try.
Unwanted and assessment of the landslide. For clearance and control of landslide or the soil. All cities completed can be taken as concrete the sign of this research and spend not taken into consideration in the investment. A2G to equals to lower line. Loan expenditure 29 million. Obviously, Proceed, heard Mr. Bhagavati, and counsel for the petitioner, as well as Mr. A. Kolita at some length. List for further hearing on same, so we notice something in his favor. You also look into it. And you also read and come.
Lordship,
It will not be offered to you in a platter.
Lordship, I will try.
You have to earn it. সোনকালে দিও, ডেটটো সোনকালে দিব আৰু আগে নোৱাৰি নেকি?
Item 13 for hearing.
May I please, Your Lordship? Father's name and the petitioner's name appear in the voter list of 1985, Your Lordship. Page 34. Ahad Ali is the father. Ahad Ali, son of Mangla Sheikh, late Mangla Sheikh. Abdul Hai is the petitioner, Your Lordship. Village Dubasuri Part 1.
Ahad Ali is the father,
Father, Your Lordship.
son of Mongla
Mongla
Sheikh.
Village Dubasuri Part 1.
Page number 34.
34, Your Lordship.
So,
Voter list of 1985.
hmm,
In 1966, Your Lordship.
Page number?
Page 32. Petitioner father name is appeared as Ahad Ali instead of Ahad Ali. Page 32, Your Lordship. Serial number 39.
hmm,
The grandfather Mongla Sheikh appeared Serial number
So
39.
now which document will show Ahad Ali is the father?
85, your lordship, total list of 85.
Who is the petitioner? Ahad Ali.
Abdul Ali.
Which document?
Abdul Hai,
Acha, Abdul Hai is there. with Ahad Ali.
85, your lordship. In 1966, your lordship, paternal uncle
Yes,
Bahaz Ali appeared. He reduced evidence.
Whether he had exhibited before the trial.
Lordship, these are exhibited.
Let the tribunal look into it because these Ahaz and Ahad
It's a
may not be
minor
because
discrepancy.
son of say Mongla.
1997 also appeared in different.
Do you have more complete voters list of 1985?
No, lordship.
Say people like Bahaz, Banji.
Their paternal uncle separated in.
I know paternal law. Do you have any voters list? Because along with Ahaz, Bahaz may also be there in the 85.
In other documents.
Banis may also be there. So if these two names are there, it is more assertive for you.
Maybe in under separate house number, it may be there.
What is the source of your information of maybe?
Lordship,
We don't leave anything to all this
but this
speculation.
Bahaz Ali appeared in the tribunal here, lordship. Paternal uncle, 1966. Paternal uncle appeared here.
Lordship, only the voters list of 66 and 70 is Ahaj lordship, and after that, everything is Ahad.
Bahaz Ali.
So now whether this 66 and 70%,
85, these two are right.
and after 70, no continuity lordship. After 70, 15 years after that,
Sir, which one?
70, 9 minutes.
Baro se hi liya इसने.
We wrote some other, what is this now? Election हुआ है ना?
Yes, your Rahman, Mr. Rahman.
Lordship.
If you go to page 34,
Lordship.
if Asia Khatun is the mother,
Lordship.
she is 34.
Lordship.
If Abdul Hai is the son, he is 22.
Lordship.
So she was mother at the age of 12.
Lordship. These are age discrepancy is there, lordship. Even your lordship.
No,
can
these
come-
are very casual statements also.
Age
Discrepancy.
37 year lordship in the total list of 1970 year lordship.
So,
Grandmother and
so
the
if at age of 12, Asia is a mother,
mother.
then Asia's name ought to have been in 1966 also, she must have been married. 85 and 66, difference of 19 years.
In 1970 year lordship.
So if it is 19 years, so she was 15 years as on 1966. So her name should have been there because she's already married. In 15 years in 1966. So Abdul Hai must have been born in 1963. So by 1963, Asia was a married lady. But
the time,
naam na tha ki bola,
Minimum age your lordship 21 years. Age discrepancy is your lordship page 33, voter list of 1970 your lordship. Ahaz Ali shown as 58 years. Ahaz Ali's mother shown as 58 years. And father shown as 62 years.
It's 66.
Voter list of 1970 your lordship,
Age 33.
33 your lordship.
Whether this Ahad Ali and lordship be Ahad Ali of 85. Because after 85, everything is in Ahad Ali's name.
Other name is-
66 and 70 documents do not match with this because the names also disappear, lordship. After Abdul Hai, there are no names.
I produced the complete voters list of 1985. The
Lordship,
petitioner to produce the complete voters list of 1985 of village Dubasuri Patla.
lordship.
Lordship, even in between voter list, because after 70, he's relying on 85, 15 years, no continuity also.
Produce the in between also.
Lordship.
Also.
Hello.
Item 14.
Rahima Khatun, Deputy Registrar Bogao through the learned government advocate. Original deed number so and so. Original deed, we'll produce it. Huda Land Government Council representing Deputy Commissioner, you are there. You have it?
Okay, one.
Original deed number. TR Gogoi, it was given.
I'm on that.
Come,
data.
Rafael, you say.
I'll take steps, my lord, because we don't have file.
MS UTAS Land Council representing Deputy Commissioner Nagaon takes notice of the order dated 15/5/2023 for doing the needful list.
10 days. Oblige.
Item 15,
No, my lord. 41. If you need it, Muhammad,
May I please lordship. My lord, I am
Bonjila Bibi.
Manjila Vidi.
14.
So, my lord, my father's name is Mujibur Rahman. My father's name is Mujibur Rahman.
Page number.
In page 21. Page 21, operative portion, page 22.
Page 21.
21, his name is page 22. Mujibur Rahman.
Father is Mujibur Rahman.
Mujibur Rahman. Now, his name is in the voter list of 2014. Actually, he has many other voter lists, but unfortunately, it was not in. I have collected that. So, Mujibur Rahman.
What is
Mujibur
the
Rahman-
unfortunate situation? Unfortunately, what happened?
That was not submitted. That is the.
We'll give you back your fortune, don't worry. You produce the documents. It did not be unfortunate.
Now we have collected this. That is.
You have collected
here
it.
with us.
Okay.
Now, Mujibur Rahman's father is Piaruddin Sheikh.
Mujibur Piaruddin. Where is the name of Piaruddin?
Yes, page 17.
17.
It is the voter list of 1966. Operative portion, page 18, Piaruddin.
Piaruddin, son of Karim Box.
And I read in a school, the school certificate.
Madhusolmari Part 1.
Yes,
Piaruddin is of Madhusolmari Part 1.
yes.
And Mujibur Rahman is of Dumar Doha
Dumar-
Part 1.
Yes. To that extent, my lord, I have proofs here. Lordship would see this is the voter list of 1991. Here, Mujibur Rahman's name appears in the Madhusolmari because he took birth at Madhusolmari. Mujibur Rahman took birth at Madhusolmari. And Piaruddin, his father, he took birth at Madhusolmari. So, Madhusolmari, Mujibur's name is there as well as Piaruddin's name is also there. So, these are the two voter lists of the list.
At
So-
birth, his name cannot come in the voters list, lordship, because the voters list which we
Let
rely
me
on.
finish. Now, well, I read in school when. In school at Madhusolmari village. And in school.
Then why your name went to Dhumar Doha for
That
1985?
I have shifted thereafter.
Then again back to Madhusolmari.
Yes, nearby village, I shifted.
And sometimes you go to Dhumar Doha, sometimes you come back to Madhusolmari.
Madhusolmari, no. Madhusolmari is the original address of my father, of my grandfather. Piaruddin. And in Madhusolmari, my lord, my father's name also appears with my grandfather.
That's what we say. First Madhusolmari, then you go to Dhumar Doha, then again back to Madhusolmari.
No,
So it a habit of going to and fro.
no, and one time, Madhusolmari, my grandfather,
See, Piaruddin is from Madhusolmari.
yes,
He is the grandfather.
yes,
So his citizenship we can accept.
Yes.
So now Mujibur is his son.
yes.
But Mujibur is son of Piaruddin of Dhumar Doha.
No. In Madhusolmari also his name is there.
Come to page 21.
No, can you see the page 91 voter list?
Where?
I have given just now. 91 voter list, can you see? It is village Madhusolmari. Right side. And Mujibur's name is there serial number 672.
He is a man of 31 years old.
At that time, he was 31 years old.
This is of 1991.
Yes.
1991, Mojibur is 31 years.
Yes.
He is son of Piaruddin
Yes.
of village Madhusolmari.
Yes.
In 1985, Mojibur is 58 years. But he is of village Dumardoha.
Well, so far as, my lord, it is matter of record, but thing is this, sometimes this, the same father's name is there, address is same. But as is, differences are there.
Mr.
That we
Mahmood, we know we can't take it so casually. You can submit casually, but to write a judgment, we cannot be so casual.
No, well, there is also the Supreme Court judgment.
That we have to write our judgments in a casual way.
Sirajul Haq's case is there,
What does it say?
my lord.
What does it?
Yes, it says that there is due to differences in names and ages
Huh.
or shifting of residence.
Mr. Mahmood, if there is a difference in name, that is Kamatullah and Kafatullah.
Yes,
Kamatullah and Kafatullah, we are all accepting.
here, that is that problem.
That is not a difficulty.
Yes.
Difficulty is age also we accept. That sometimes a little
Yes.
slight variation here and there don't give strict interpretation. But how 58-year-old Mojibur, son of Piaruddin of Dumardoha, can be understood to be 31-year-old Mojibur, son of Piaruddin of Madhusolmari. When 58 years he was in 1985 and 31 years is in 1991.
Yes.
The petitioner to explain under what circumstances the court can accept that Mojibur Rahman, son of Piaruddin, of the 1985 voters list of village Dumardoha Part 1, where his age is 56 years, is the same person as that of Mojibur Rahman, son of Piaruddin, of the 1991 voters list of village Madhusolmari, where his age is shown to be 31 years.
So far as better is the adversary came to
A
the.
list
Yes.
next week. The petitioner to file an affidavit on the aforesaid question.
Item 16.
Mr. Mahmood, we are giving you a lot of leverage, lot of
Yes.
free play.
We
But
understand.
sometimes when the free play exceeds the limit, it is difficult to accept.
Yes,
So
well,
you file affidavit.
I will call client and take explanation.
Yeah.
Region.
Something must be wrong somewhere.
And there is another judgment. our
Means
High
we are
Court-
not taking any very strict technical view.
Yes.
We are not rigid at all.
Yes.
Enough of flexibility to absorb you in all possible manner.
Another judgment,
But-
my lord, our High Court has, that is.
Forget about judgment. First prove your case. Judgments will come later on.
I'll satisfy that.
You'll see how.
May I please? Kindly see the page 31.
They're going to be page 31. correct?
Yes. Sir. Relevant portion, page 32.
Bor Balulchar. Khasrat Ali Sheikh is the father. Which document will show?
Now, Lordship, kindly see page
Mhm.
33.
Sorry,
Page 1970 voter list, Lordship, kindly see page 30.
what is there?
That is also, Lordship, my mother's name is there along with my father.
Kalasan is the mother.
Yes, Lordship.
Okay, fine.
Now, Lordship, kindly see page 35, next page.
T5.
Next page, 2005, shifting is there, Lordship. This time my parents' names were appeared in from Bhati Petla.
How do you prove the shifting?
That is the problem.
The petitioner may produce any material that Khasrat Ali Sheikh or his family, whose name appears in the voters list of 1966 and 1970 of village Boro Balulchar, had later on shifted to village Bhati Petla so as to enable his name, the name of his wife to appear in the voters list of 2005.
17,
An affidavit be filed with the explanation.
17 may be taken up of other day.
17 is even worse.
item 18,
None appears for the petitioner when the matter is being called. It is noticed that on 23/7/2021 also, when the interim order was passed in favor of the petitioner, none had appeared. List again. Further non-appearance shall entail appropriate orders.
Our appearance may be,
Uh,
our
Ah.
appearance may be recorded, Lordship.
item 19,
Yes. Abdul Samad,
Your
will you-
Lordship, we want to file an additional affidavit to bring on record the exhibits.
You want to file additional affidavit. Your name, ma'am?
B. Hazarika.
B Hazarika, MSB Hazarika, like, prays for some time to find an additional affidavit, pray aloud, based on which.
item 20,
May I please, Your Lordship. In this matter, my lord, Mr. A.R. Bhuiyan is supposed to appear, but
Sorry,
Mr. A.R. Bhuiyan is supposed to appear, but due to fever,
A.R.
he is
Bhuiyan.
not available, my lord, today.
Huh?
And that apart, my lord, we.
what apart, the air here, what happened to him?
He's suffering from fever from yesterday night, my lord.
It's stated that Mr. A.R. Bhuiyan, land counsel of petitioner, is suffering from fever. List again.
21,
क्या नाम पे लिखी was stated by so and so. क्या नाम पे किया से? MIMAI. Yes, Mr. Ahmad. Kormaka. Yes.
My lord, father of the petitioner is my lord. Jagadish Komakar, my lord.
Page number.
Page number, my lord, 12, my lord. There is a refugee resident certificate, my lord. In the name of the father of the petitioner, my lord. Jagadish.
Jagadish Kormaka. He is the father.
He is the father, my lord.
52.
And he.
Which
had a-
document will show Jagadish is the father?
My lord, there is only a school certificate, my lord, because thereafter, my lord, shifting is
Page
there.
number.
Page
No,
number, my
with
lord.
these people with refugee registration certificate, one very difficulty is
My lord.
certificate does not indicate where that person is located.
Yes. my lord.
That certificate only indicates the time when he came into India
Came into India.
and from where he came. After coming into India, where this man goes, nothing is available.
My lord,
So
yes.
next time, any person with Jagadish Kormakar anywhere in this Assam can be claimed to be that he is my father Jagadish Kormakar. Whether he is the same person or not, we have absolutely no means to know.
My lord, in the certificate, my lord, there is a my lord indication, my lord, that he had entered in village Athiabari, Moza Govardhan, although it is not, my lord, very much legible, my lord. But it is a part of record. my lord.
Now in village Athiabari, okay.
Under Borpeta, my lord. District.
Understand. So now you show that Jagadish Kormakar of Athiabari is the father, shifting is there.
My lord. My lord, in the school certificate, my lord, page 17, my lord,
Hmm.
of the petitioner, my lord.
Hmm.
The name of the village, my lord, has been mentioned as Pithadi, my lord.
Hmm.
And that is also under, my lord, same, my lord, district and same police station, my lord.
Well,
Govardhan.
these will not help you, same district.
And
Uh,
police station is also same, my lord. Pithadi has been converted to, my lord. Later on, my lord, this earlier village, my lord. Athiabari, my lord.
Haripada Kormakar, Jagadish of
Chandra.
Pithadi. When did he study? 1973. High school. What school is this?
HE
means?
school, my lord.
Huh?
It is, my lord.
What is HE school, Madam Verma? HE school. What is it? HE school.
H-E.
HE. High,
17.
is it ME is for HE or something?
17.
Hmm. This is your certificate.
My certificate.
No, Verma, why can't you do one thing?
Yes, Lordship.
All for this records of this school. See, he paid fees up to 1973. That is of a close proximity of 25/3/1971. It's a high school. If he was a student, enrolled student of that high school prior to 71, that is a good material to show that this man was, this at least Haripoto was there in 71.
Yes, ma'am.
Yes.
Whosoever his father may be, he himself was there. Instead of linking up with Jagadish of that refugee certificate, on his own, his
can-
presence is established.
Coming from East Pakistan, thing, from this, because Lordship will annexure to page 14.
No, you are not
Eternal-
understood what you say. We are not on page 4.
Eternal.
Okay.
We are on page 17.
Page 7.
No, I was in. that
See the
also.
information, all sums due have been paid up to 1973.
Yes, ma'am.
That means this person must have been in class 9. It is
Yes.
in class 9 in 1973. If it's a high school, he must have entered that school at least 3-4 years prior to this date. If the school record shows his existence prior to 71,
73, he was in the school. And he
That
was
was-
18 years old at that point of time.
so if he entered the
Yes.
school before 71 and this is his certificate, this certificate alone shows that he existed in 71.
But there is a overwriting in the certificate, Lordship will see first. if
No,
the
so we
district
call for the school, we
District
call for
earlier
the school
was-
records.
then it
We don't
was-
go by certificates.
Converted to Borbet.
council-
But it's Madam Dekha. Give a copy to her. The school admission register as well as the attendance register of Bagodi Government Aided HE School
Can I go home? Google no आया.
in the Borpeta district
It's never come, Rupam.
for the years 19 69
You know, original one,
say class 9 high school class 7 or say 71 70 from the years 1970 onwards up to 1973 be produced before the court. A copy of the order may be made available to MSB Decca.
My lord. The father of the petitioner died, my lord.
No,
in
then you
1964.
don't need any other document.
Therefore, will write, not link up. If
You don't
father
link
died-
up also. You on your own
My lord, my lord.
existed there.
I love it.
Item 22.
No. I'm building someone else here. It will go into the footage. It will be some of this particular.
page 17.
Yes,
Others name appeared at page number 25, my lord.
page number
25, my lord.
25.
My lord. Total list of 1965 of Katlichara LLC, my lord. Rahmat Ali Khan, my lord.
Rahmat Ali is the father
My lord.
and Salema
She's
mother,
Stepmother,
stepmother.
my lord. Next page, my lord, page 27.
Hmm. What is the name of the village?
My lord, Apin Grant Golf Acquisition Area, my lord. This is under Katlichara constituency, my lord.
Apin Grand Government Requisition Area.
My lord.
What kind of a name is this?
The name of that particular.
Government path again. Anyway,
Now, my lord, page 27. By the name of the petitioner appeared with his father and stepmother.
petitioner is Sirajuddin.
Din Khan, my lord.
Where is Rahmat Ali and Sirajuddin together?
Page 27, my lord.
27.
Well, here it is Khan, my lord. It's from Khan.
Just go back.
Now, my lord, another thing, my lord. I have
Don't want to go back.
Hmm.
Then we dismiss.
one submission. My lord. I have submitted the deletion certificate before.
Sorry.
I have shifted to Gulagat, my lord. I have submitted deletion certificate of 2010 before the exhibited before the tribunal. It was not considered, my lord.
What certificate?
Deletion certificate.
Sorry.
I have deleted my voter list from Hailakandi.
He shifted to
Shift, my
Golaghat.
lord. Annexure.
No, you before the tribunal, you go and prove yourself that you are Sirajuddin Khan of that 75 voters list. That's all. Sirajuddin Khan, son of Rahmat Khan of 75
My-
of Apin Grand, we are satisfied he may be a citizen.
My-
You go and prove yourself that you are that man and not another Sirajuddin. How you prove is up to you. We are sending it back for that purpose.
Then that exhibit may considered, my lord. I have exhibited here.
The last exhibit of 2010,
10, my lord.
that doesn't matter now. He has to first prove it earlier,
My-
lordship. He may
Today,
use
you
it-
may be in Golaghat, you may be in any other place.
My lord.
You go and prove before the tribunal
Lordship.
that you are
75.
Sirajuddin Khan of that 75 voters list.
Lord-
Safe, lord.
lordship.
And how you prove, you think about what material you have to show.
Right.
Third, Mr. J, no? Third, Mr. J. Law Scotland. on your petition also. Sirajuddin Khan had been referred to the Foreigners Tribunal number.
Johat.
To the Foreigners Tribunal Jorhat for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25 May 1971, resulting in registration of case number FTG bracket D 79/2011. The tribunal rendered an opinion dated 8/5/2018 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of
Page 25.
25, relies upon the voters list of 1965 of village Apin Grand Government Requisition Area under police station Katichara in the Kachar district, which contains the name of Rahmat Ali, son of Yusuf Khan at serial 5 and that of Solema Khatun, wife of Rahmat Ali at serial 6. And both are shown to be residing in the same house number 74. Petitioner thereupon relies on the voters list of 1975 of village Apin Government Requisition Area, which contains the name of Rahmat Ali, son of Yusuf Ali at serial 8 and that of Sirajuddin Khan, son of Rahmat Ali Khan at serial 10, and both are shown to be residing in the same house number 61. The petitioner claims that Sirajuddin Khan of the 1975 voters list is the petitioner himself. If the petitioner proceeds Sirajuddin Khan and Sirajuddin Khan of the 1975 voters list of village Apin Government Requisition Area are one and the same person, the petitioner may have discharged the burden under Section 9 of the Foreigners Act 1946. But whether the two are the same person, a determination would be required. For the purpose, remanded back to the tribunal to examine the voters list of 1965 and 1975 of village Apin Government Requisition Area, and allow the petitioner to discharge to produce any material to prove that the petitioner proceeds Sirajuddin Khan and Sirajuddin Khan of the 1975 voters list of village Apin Government Requisition Area are one and the same person. Upon doing the needful, a reason order be passed. The respondents in the Home Department through the Sumendri border may also make their own verification on the aforesaid issue, whether the writ petitioner proceeding that Sirajuddin and Sirajuddin are one and the same person.
All right.
23.
Made.
23.
My lord,
Sabahan Ali.
Subhan Ali, my lord.
Yeah.
My lord, page 13, my lord.
Third.
Certified Jamabandi of the father of the petitioner, my lord, for the year 1957 to 1964, my lord. My father's name is Fazur Sheikh, my lord. Alias Fazur
Sorry,
Ali.
this is Jamabandi.
Yes, my lord.
Jamabandi of which year?
My lord, 57 to 64 year, 64, my lord.
Who is the father?
Father, my lord,
Rahiz,
Fazur Sheikh.
Rahiz or Fazar? Fazar.
Fazur, yes. my lord.
Fazar is the father. Village Tamulgi.
Tamil,
Okay,
yes.
now which document will show that
My-
Sabahan Ali is the son of
My lord,
Fazur.
page 23, my lord, voter list of 1985.
23,
Yes, my lord.
Tamulgi. Yes, sir.
There should be voters list.
Sorry,
but he should have prior voter list also. Why of 1990, lordship?
85, 23 is 85,
This is
85,
Page
and
25.
13 is of 60, Jamabandi of 57, 64.
yes, lordship.
Where is the Jamabandi? You have a copy of it?
It's a translated.
My lord,
one.
yes, my lord, original, my lord,
page.
at page 14, my lord.
Adore away season again.
The parents voters list. There ought to be one because if
No,
the
no.
voters list is of 37 years.
Tamulti, You produced a complete Jamabandi. This is only one entry in between. The petitioner to produce the complete Jamabandi of the plot of land at village Tamuldi, which may enable the court to examine as to whether Fazar Sheikh, son of Sabit Sheikh, was a landholder.
24.
Please, Your Lordship. My lord,
The father-
and you would come to page, my lord, 53, my lord. The petitioner name available in 66.
Who is the father? Kurban.
My lord, petitioner is Korimun Nessa. Kurban is the, my lord, Kader is the husband.
No, who is the father?
Father is the Kurban, my lord.
Father is Kurban. That's why I'm asking.
Kurban,
Father is Kurban.
Kurban,
Kurban, son of Noser,
my lord,
of village Dubasiri.
my lord.
Father, 71.
Page 53 is the, my lord, page 53 is the.
No.
Like 266 totally, two, one from father side, another from husband side.
Don't do so much of things. So you claim Kurban Ali, son of Noser, is the father.
My lord,
Where is the name of Kurban Ali, 1966?
my lord, page, my lord,
53.
page 51 is the, my lord, 66 voter list.
No, 66 is 53. Abdul Jabbar Jaitun Nessa,
No, lordship.
My lord.
Kurban Ali is on page 51, lordship.
51.
51,
And 53, I think it's with the husband.
husband, my lord.
Acha, by that time she is already married.
Married,
Nosar Ali, Kurban Ali father. Nur Jahan is the mother. So petitioner is Korimun Nessa.
Korimun Nessa.
Lordship, in 66, if the father is 25 years, how can the daughter be married? She's just 22 years, lordship. What is my friend trying to establish?
My lord, some error, my lord.
No,
But
what
in the
kind of error,
53,
lordship, is
The
this?
error cannot be everything is
glaring.
upside down. Error, a little bit of error we understand.
Now, which
And
one
even
do
if
we-
it's an error, it must have been corrected in a subsequent voters list.
my lord.
Where is
Then, my
that?
lord, 70, kindly page 54.
No, Karimun is 22 in 66,
My lord,
and
27 in 1970. number one,
My lord.
and Kurban is 25 in 1966. And that Kurban is 27 in 1970. How Kurban can be father of Kariman when she's
Wife of some Kadir lordship.
the wife of Kadir?
If your lordship kindly see page 50.
Let him explain
Mr.
these
Page
two documents first.
Something wrong.
My lord, in the NRC 1951, page
Please
49.
don't,
Here
first
father
you
is
explain these two documents, then you jump to the next one. You just cannot keep jumping without explaining.
The petitioner relies upon the voters list of 1966 of village Dubasuri, which contains a name of Kurban Ali, son of Nasir Ali, age 25, at serial 39. And that of Nurjahan Begum, wife of Kurban, age 21, at serial 40. 1970 voters list of village Dubasuri contains the information, contains a name of Kurban Ali, son of Nasir, age 27, and Nurjahan Begum, wife of Kurban, age 23. Petitioner claims that she is the daughter of Kurban Ali of the 1966 voters list. To substantiate the same, petitioner refers to the voters list of 1966 of village Dubasuri Part 1, which contains the name of Kariban Nessa. It is claimed that Kariban Nessa, wife of Kadir of the 1966 voters list of Dubasuri Part 1, is the petitioner. But it is noticed that the age of Karimun Nessa as on 66 was 22 years, which again was 27 years in the voters list of 1970 of Dubasuri Part 1. If Kurban Ali, the father, was 25 in 1966 and 27 in 1970, the petitioner to explain as to how Karimun can be his daughter, being aged 22 years as of 1966, meaning thereby that if the father is 25 years and the daughter is 22 years.
I am denying page 53 and page, my lord.
We'll hear you first, then you withdraw that argument, relying on 66.
It's already
Father said I am
exhibited.
withdrawing, my lord. Regarding
It's
father,
already exhibited and is relying on those
I
documents
understand.
heavily.
You are relying on page
page 53, my lord.
53, we have already taken note.
Then my lord, page 49. There is a my lord, some
49 also, we have
49 is
already,
a, my lord, NRC, my lord.
we have already taken note.
Page
We have-
49, petitioner age is 2. Age was 2
No,
years.
But NRC, we are not taking lordship.
NRC is not
It's
admissible.
not admissible.
I know. This, Dr. Ravi.
25.
Highly obliged, your lordship.
Page 18 may be seen down. Page 18. 2015 voter list also. Page 19 is relevant worship. Abdul Khalik is my father.
Porwa,
Yes,
village Porwa, 2015.
yes, Lordship.
Khalik
Abdul-
is the father.
Yes.
Then who is the
Pulwama
grandfather?
Mother and.
Very well. Who is the father? Grandfather, Maqbul.
Yes, Lord.
Where does the name of Maqbul appear?
Page 28.
Hmm?
Page 28.
20. What is page 20? Your name, Mr. Counsel? Mr. Sarkar,
Yes,
you are referring to page
28.
18 and 19 to say that Abdul Khalik is the father of the petitioner.
Yes, Lord.
This is a voters list of 2015.
Yes, Lord.
So to establish you are a citizen, you have to show that the father Maqbul Hussain is a citizen.
Yes,
Where does the name of Maqbul Hussain appear?
page 28.
28.
8.
Which one in this one, page 27? So here translates to Kota. Next to the 8 to NHS 6. Which Maqbul are you talking about? This one.
And page 20.
The petitioner to produce the complete voters list of village Poroa between the years 1966 and year 2015.
Was in 1989 voter list petitioner's father's name and.
You produced the
grandfather's name.
complete ones. You produced the complete voters list of all these years. Then some pattern may come out, otherwise it's difficult to accept it this way.
Lordship, in 2015 petitioner's name and petitioner father names is appeared.
That's too late. First you show the first
No,
one.
2015.
Item 26.
If you cannot take the help of Mr. Ali, ask him. Make a request. Almazuddin Mozumdar,
My lord. His father's name is Abdul Latif
page
Majumdar.
number 16.
16, my lord. Initially, my lord, Majumdar was not there.
Abdul Latif is the father.
Father, grandfather.
Almazud, he is the father.
Father,
But which document will show Abdul Latif is the father?
my lord, then page 34, my lord,
Page number
34. Total list of 2005, my lord, of same constituency,
page number 34.
34.
That 35 is the vernacular.
One,
That one. Abdul Latif Mozumdar.
Secretary Majumdar.
This is village Shivpur.
It was part 2.
Hmm.
66 is a
This
single
is
name.
of which,
voter
this
list,
is of
Lordship.
which district? Kachar.
Achar district.
Where is the name of the village?
Village, my lord, at the top, my lord, circle number 53, village, part 2, my lord, page 16, my lord.
No, no, in page 35, where is the name of the village?
35, my lord, Vote Kendro, Nam, Shivpur, Nimno.
Vote Kendro in village.
No,
may
my
not
lord,
be seen.
at the second line, my lord, Ramu word now, Shivpur, Tityo Khando.
Aste ko ba?
Lordship,
ওইটু উপরে তো গ্রাম এবং
Lordship, all along his voters list is a single name voter list. The mother's name is also nowhere there. And.
produce the complete
Lordship,
voters list of
Yes,
Lordship, may I
1960.
submit, my lord, on being regard earlier this.
You don't submit, you produce the documents, we'll examine. The petitioner to produce the complete voters list of village Shivpur part 2 from year 1966 to the year 2005. Complete voters list, all the family members.
May I submit one thing, my lord? Earlier petitioner approached this honorable court, my lord. Matter was remanded before the tribunal again, my lord. I was behind the detention camp, my lord. Only to prove whether Almaz, my lord, Abdul Latif Majumdar and Abdul Latif is same and one person. Now, on being remand, my lord, I have approached, my lord, before the tribunal, my lord, I have adduced evidence, my lord. Now, tribunal even disbelieve the executed document, my lord. May I have all shown one.
This way, pastor order, please produce the document.
Lot. Public.
27.
Mr.
My lord.
If you want us to change our procedure in your
No, my
case, your colleagues will be in more difficulty.
Sorry, my lord.
Because we have adopted the most strict process. You discharge your burden before this court.
Lordship,
Once you discharge, we'll deal with the matter.
public.
But if you intend to go into the mistakes of the tribunal, then in many cases where we are allowing will also have to be dismissed.
Lordship.
So tomorrow you'll be in more difficulty.
May I please, your lordship. Voter list of 1965, page
65, page number,
26, your lordship.
sorry,
26, 26.
26.
Here, lordship,
26, who is the father?
Jonavali is the father.
Janavali father.
Raidan
This is
is mother.
65, village Rongadoria Gao, Nogao.
Raidan
And
is the mother.
Mohibur Rahman, which document will show Mohibur is the son?
Page 34, your lordship.
34.
And Barnakula, 35, your lordship. Father's name is not there, mother is there, your lordship.
34, Rongadoria. Who is the mother? Raijan?
Rajan baby,
Raijan is the
65
mother.
and 65 also there.
Mother, Raijan, mother. And Mohibur is the petitioner.
Petitioner.
Go back.
And produce the complete voters.
Ah, yeah, definitely. Not just one or two deeds, produce all the complete voters list.
70,
heard,
75, 85 is there.
Let it remain, you produce all the complete voters. Heard,
And continuous ones, lordship,
thank you.
because just convenient ones are there.
And then ask the tribunals to also insist on the complete voters list. Ask the tribunals to also insist on complete voters list, continuous voters list. A lot of pattern emerges if these complete documents are there. Otherwise, what the people do, they just pick up one entry here,
Yes.
another entry after 20 years. This is this, this is that.
Whenever the election officer, they are someone, the lordship, they always bring the record complete voter list. So they can scrutinize.
So the tribunal can start adopting that matter. The way
Yes,
We have to.
it is being done here, they can also do
they
it.
can call for the record,
Huh.
the department will bring it and provide it.
Your name Raman, P. Rahman. What did you name? The petitioner Mujibur Rahman had been referred to the. Where is the order of the tribunal?
That is at page 23, lordship.
23. Had been referred to the foreigners tribunal number 3 Morigaon for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971. Resulting in registration of case number FT 47/2015. Tribunal rendered an opinion dated 28/8/2019, declared petition to foreigner. The writ proceeding reliance is placed on the voters list of 1965 of village Rangadoria, police station Mikir Bheta, Moja Mikir Bheta in the Nagaon district, which contains the name of Janab Ali, son of Ismat at serial 494, and Raijan, wife of Janab at serial 495. It is claimed that Janab Ali is the father and Raijan is the mother. Reliance is also placed on the voters list of 1993 of village Rangadoria, which contains the name of Raijan Bibi, wife of Janab at serial 318, and that of Mohibur, son of Janab at serial 320, and both are shown to be residing in the same house number 189. It is claimed that the name of as the name of Mohibur appears along with Raijan Bibi in the voters list of 1993 of village Rangadoria, and the name of Jainab Ali and Raijan appears together in the voters list of 1965, also of village Rangadoria. The petitioner had discharged the burden under section 9 of the Foreigners Act 1946. In view of the matter remanded back, the tribunal to insist upon the production of the complete and continuous voters list of village Rangadoria from year 1966 to 1993, which the petitioner may produce, and if it is not possible for the petitioner, the authorities in the election commission may be required to produce the complete voters list. Upon the same being produced, the tribunal to examine the implication thereof and pass a reasoned order. If there is a continuity in the entries in the voters list of Janab Ali, son of Ismat, Raijan, wife of Janab, and that of Raijan, wife of Janab, and Mohibur, son of Janab, the tribunal may pass its order. The respondent may make their own verification as to whether Mohibur of the 1993 voters list of village Rangadoria and the petitioner Mohibur Rahman are one and the same person. Yeah. In doing so, reasoned order be passed.
Hello, please.
No. How many more matters? 2 matters.
2 matters.
Come back and pick.
Yes,
Or do you want to one an extended session?
no, lordship, we are here.
Item 28,
May I please, Lordship? Here, my lord, by common order, 4 persons were declared as foreigner of post 71 by a common order. Now, the notice was under. My lord, including Mia Hussain.
Including Mia Hussain.
Yes, whose name appears, his own name appears in the voter list of 66. Actually, his correct name is Messen Ali, but it is written. His own name appears in the voter list of 1966 and 70. Even then he was declared. That was on record also.
No, no, now Mia Hussain or Messen Ali
Yes.
and his
Three
family
sons.
members were declared to be foreigners.
With 3 sons.
Against whom the reference was made.
Reference, my lord, I have not the copy, but so far my knowledge.
It's there in the big record. That one.
Notice was, my lord, notice was sent to us as the stream of 1166.
No, no, not notice. Who was referred?
Reference.
Lordship, can we look into the records?
So if Mia Hussain was referred, notice could not have been to the entire family.
The notice have also been sent to others.
Why dear honor? It could not have been. Mr. Mamu,
Lordship, there were 4.
when we are
references.
saying something in your favor, even that also you are refusing to understand. In your anxiety to
Yes, sir.
present your case, you don't even notice the views, what we are saying, which is ultimately in your favor. So, so that means the other family members cannot be proceeded. But, Madam Verma,
Yes,
but
Lordship.
Mia Hussain is no more.
Yes.
Otherwise, had he been alive, what we would have done, we would have discharged the other 3, if necessary, proceed against them.
Yes, Lordship.
Mia Hussain, we would have determined on his merit. But here, Mia Hussain is no more. So now, on his death, his legal heirs are before the court.
Lordship,
Now, legal heirs are espousing the cause of
Father,
father, not their own cause.
Lordship.
So they, as petitioner number 2, 3, and 4, them we can discharge. Then we can determine the citizenship of their father, Mia Hussain.
Reference, the inquiry was, the reference was only for Mia Hussain.
Hmm.
But there are 4 different cases, and 4 different cases, one opinion was found.
Actually, there are 4 different cases.
Yes, Lordship.
And that means 4 different
Four
references
different-
also.
3, yes, there must be, because I had just opened the file and I
Hmm.
saw that the first
Because
notice
there
was
are a number of aspects. One, the authorities may feel that it is one family. So one family, either in one reference, everybody is proceeded, or there are separate references as in this case. But the tribunal goes by one opinion.
Yes.
That will rule out the possibility of someone taking a stand that I don't belong to that family. I'm a totally different person. Although I have been noticed and brought into this proceeding by saying that I'm a member of that family, but I'm not a member. He has that right to say that also.
There were 4
So-
police inquiries, Lordship. That means
So
4 references.
why we are against these common opinions? These are all individual references.
But they're sons of
Hmm.
Mia Hussain. There were 4 references, 4 inquiries and 4 cases.
So we do one thing, let us send back all the 4 references to be decided independently.
3 now, father's.
Now it will be 3. Let them prove it. And regarding Mia Hussain, these others will have the right to prove that he is also a citizen. Because otherwise they will be stuck. Or will provide that the fact that Mia Hussain had been declared to be a foreigner that will not be a reason for the tribunal to hold against these people.
But they have already contested, Lordship. They have contested. It is not that they have not.
No, it's
submitted.
a common opinion.
Common opinion, but they have contested with
Understand?
documents.
Common opinion is, we are not, we sent back a number of cases on a common opinion. Without expressing anything at all. Normally what happened, when you remand back, we express something against the order of the tribunal. Here, we are not expressing anything at all.
But therefore.
No view is expressed, just past separate opinions, again, in respect of the separate references. In the meantime, one had died.
Yes, father has
But-
died.
The earlier opinion formed against this one, anyway it will go, we'll be setting aside. That will not be a basis to go against them. They will independently prove their citizen. They will also prove in doing so that they are sons of Mia Hussain and that Mia Hussain himself is a citizen.
What I can see is, Lordship, they have all four of them contested. The only mistake the tribunal made is because the documents were same, so they passed a common judgment. For each case, if had the tribunal passed individual judgments, this problem would
This
not.
would
have
not have
arisen.
come.
Because the all documents are same. And they belong to the same families and four references, four police inquiries.
So let the tribunal rely on the same documents, pass a new
And-
order.
and
New
pass-
order
And
separately,
pass three different
three different.
opinions.
And in doing so, any opinion already formed against the deceased Mia Hussain shall not be influenced upon. It should be independently decided. You may form the same opinion, but reason should be independent reason, not because of that one.
That link will be the father only, no?
And that's why I say. So now they will prove that the Mia Hussain is a citizen.
Is their father and a citizen of India.
Otherwise, they cannot prove their own citizenship unless they prove their father is a citizen. They will prove it.
So these documents may be allowed to be submitted.
You submit anything, you prove your citizenship. And in doing so, if it is necessary to prove that the father Mia Hussain is also a citizen, you'll be free to prove that also.
It is on his own name is reflected in the voter list of 66, own name.
Now you go and prove it. Go and prove that that person and this person is same.
Are the same people.
Mia Hussain alias Mesen Ali. Actually, my name is Mesen Ali.
Whatever it is. Prove everything. Wherever there is any doubt, bring more material to remove the doubt. Wherever there is any gap, bring in more material to fill up the gap, so that one continuous chain is noticed and a decision can be given, either yes or no. Heard Mr. M. U. Mahmood, then counsel for the petitioner, also heard that he's already revoked. Four separate references were made against Mia Hussain
Page 133.
page 135 against Yes, emotionally high. How many cases were registered?
Four Lordship.
Where did you
police
get those
inquiries.
numbers? Page 134 is only one number is there.
No, Lordship, it's
33,
there in the
133.
records.
30.
Records have it, Lordship.
কি বলো? Against Mia Hussain, son of Afazuddin, of village number 1 Dolabari, resulting in registration of FTD case number 15382012, semicolon. Chand Mia, son of Mia Hussain of number 1 Dolabari, in FTD case number 1686/2012, Shahid Ali, son of Mia Hussain of village number 1 Dolabari, resulting in registration FTD case number 1545/2012, semicolon diba, and Suraj Ali, son of Mia Hussain of village number 1 Dolabari, resulting in registration FTD case number 1543/2012. Going by the name, identity, and residence of the proceedings, the tribunal deemed it appropriate to pass a common opinion in the 4 reference cases indicated above. Full stop. It is always safer to pass individual opinions in separate references. Although in certain cases, it may appear that all the proceedings are from the same family. We accordingly interfere with the opinion dated, common opinion dated 30/10/2019 in the aforesaid reference cases. During the pendency of the present writ petition, the proceedee Mia Hussain son of Afazuddin died, and in his place, Sania, Shahid Ali, and Suraj Ali, being they are the original petition number 3, 4, and 5.
Yes.
2, 3, and 4. Being the original writ petitioner number 2, 3, and 4 had been substituted as legal heirs of the deceased writ petitioner number 1, Mia Hussain, alias Mesen Ali. কি বলো গোটেইখিনি পঢ়াচোন হেৰি লাষ্ট আগে কলো সেট এসাইড বুলি কলো নেকি ইন্টাৰফেয়াৰ বুলি কলো নেকি কি কলো তাৰপিছত কি কলো এইটো সেপাৰেট কৰি দিবা হা সেপাৰেট কৰি দিবা as the issue of the citizenship of the petitioners had not been gone into on the question of merit by the court, and it is only on a technical reason that it has been interfered and remanded back. We provide that 3 writ petitioners, San Shahid Aru Heri, shall appear before the tribunal and prove their individual cases that they are citizens of India by providing any material that may desire to produce, including the materials that have already been placed before the tribunal. As Mia Hussain alias Mesen Ali had died in the meantime, the reference made against him may be returned back by the tribunal to the referring authority as referring back to his authority. In the event the citizenship of Mia Hussain alias Mesen Ali would remain undetermined, that is, not conclusively determined whether he is a citizen or he is not a citizen. As petitioners number 2, 3, and 4, namely Chintanam, Sanmia, Said Ali, and Heri, would be required to prove their citizenship, which can be proved only through their father, Mia Hussain alias Mehsen Ali. The 3 petitioners would also be at liberty to produce any material before the tribunal to prove that Mia Ali alias Mia Hussain alias Mehsen Ali was also a citizen.
Lordship has just said to return it back to the referring authority. If it is referred back, then this matter will not have its logical conclusion, Lordship.
Which one?
The father, Mia Hussain,
Father, he is gone.
he's gone.
Huh.
But-
So now sons may prove his citizenship to
Exactly.
prove their own citizenship.
Yes.
That's all. Enough.
Any documents to show that.
that's what I
their
say.
father was.
So now as they return, Mia Ali's citizenship will remain undetermined because of the returning back. But the sons to prove their citizenship, they will also have to prove that Mia Ali is a citizen. Otherwise, they can't prove their own citizenship.
Exactly, the chain would.
So they will prove his citizenship with anything, that he himself was a citizen. Like what you happened when you suppose the father has died long back. What does the procedure do? He says, I am the son of so and so, and also prove that that so and so is a citizen. Same thing they'll do here. Okay? As the matter is, as it is a reference of the year 2012, we request the tribunal to dispose of by passing separate opinions within a period of 3 months from the date of appearance of the petitioners, number 2, 3, and 4. The petitioners they appear on so and so.
That is impliedly stated.
Sorry.
In doing so, the tribunal may not be influenced by the earlier order passed against Mia Hussain.
No, that is already set aside. We interfered.
Set aside, obliged.
The tribunal shall pass independent opinions on the merit as may be claimed by the petitioners number 2, 3, and 4. Anything more to be provided?
No, Lordship.
And in doing so, they will not be influenced by Mia Hussain's order. That is our prayer.
No, they'll be influenced only by materials produced. That's all.
Because first your father has to be proved.
Father from graveyard.
That will be a little dangerous. Tomorrow, if somebody will raise an argument that not be influenced means earlier it was said to be citizen. Now you cannot say him to be a citizen. So they'll be influenced only by the materials produced. Nothing else. Petition disposed of in the above terms.
Twen-
29.
29.
May please, your lordship. My lord, this matter is heard earlier, my lord, and now.
It is noticed that English translation of the vernacular page number is at variance from the
Yes, my
vernacular.
lord. That has been translated afresh and enclosed in an affidavit. So, my lord, matter can be, my lord, remanded back, my lord, considering the documents, my lord.
Let me hear you.
My lord, that Panchayat certificate, we are also not relying on that.
No, we have to hear your merit. If you can satisfy, we'll definitely
My
satisfy.
lord.
Lordship, I pray for a copy of that affidavit filed. that
Yeah,
translated.
A copy of the affidavit filed subsequently be provided to the land council for the home department. List on so and so.
My lord.